So I have a couple of goals for our time together. First of all, I want to make sure that you understand the context for the legal doctrine of separate but equal, the court case it came from, and how it was actually justified at the time it was put in place. And second of all, also like to make sure that we understand how the Supreme Court was able to strike down separate but equal, and the Supreme Court's justification for doing so at the time, which differed quite a bit from the way that separate but equal is justified in the first place. Now, we're going to do this by two bookended cases. These have to do with, on the one hand, in the 1890s, Plessy versus Ferguson, and in the 1950s, Brown versus Board of Education of Topeka Schools. Now, all of this, to a certain extent, is a story of the 14th Amendment. If you remember from earlier lessons, you'll probably know that the 13th and 14th and 15th Amendments were passed following the Civil War to establish citizenship and basic rights for the newly freed African American slaves. The 13th was an amendment that actually ended slavery itself. In the case of the 15th Amendment, it was guaranteeing universal male suffrage, and so in this case, African American men as well. And then there was the 14th. The 14th, in order to make sure that all protections were given to African Americans that were given to ordinary citizens, it made African Americans citizens. And the way they accomplished that at the time was birthright citizenship. You were born in this country, then you are a citizen and have all the rights of one. So the way that this is worded in the 14th Amendment has some critical importance for our discussion. Specifically, Clause 1, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. And a little later, no state shall deny to any person within its jurisdiction the equal protection of the laws. It's that equal protection piece which is at the center of the two debates we're going to see, both not necessarily just what equal protection means, but also who it applies to and why. Which brings us to our discussion of what led up to, I should say, the separate but equal doctrine in the first place. After Reconstruction ends in the South, following the 1876 presidential election, you have many of the laws which had guaranteed rights to newly freed slaves, African Americans, stripped away, and you had a body of laws in place, also called the Black Codes and collectively later referred to as Jim Crow, which were responsible for restricting and separating Black Americans from a variety of different privileges, services, and public facilities and locations. Now, you're familiar with a number of these. Only being able to, say, sit in a back corner of a restaurant, that is, if you were allowed to patronize it at all, being in separate classrooms for your schools, even being in separate places for using the restroom and or something along the lines of a drinking fountain. However, this was something that was very given a reality and justified state by state. We didn't necessarily have any one set of Supreme Court body of precedent that was justifying this. Not any one, per se. That came in the form of our next case. Now, one of the things that was a key place where separate but equal segregation was beginning was in transportation. In the early 1890s, in Louisiana, their state passed a separate car act, which is to say it required all of the rail car companies to provide separate seating, in other words, separate cars for African Americans and white people. And if they could not, then they needed to segregate them in different sections of the same train car. Now, you had a number of voluntary associations favorable to civil rights in Louisiana, particularly in the New Orleans area, that wanted to try and challenge this if they could. The way they were going to do so is have a test case. They persuaded a man named Homer Plessy to board a first-class train with his ticket and see what would happen when he was identified as African American. Now, an interesting factoid in this is you can kind of look at Homer Plessy's portrait shown here, and I think what you'll see is it's not immediately obvious that he is quote-unquote African American. Matter of fact, he has only 1/8 African ancestry. However, of course, the point being is that under the sort of blood quantum way that the Old South thought about race, even 1/8 was too much. And therefore, once it was known that he had some black ancestry, they arrested him and pulled him off the train. So, he and the voluntary association who recruited him are going to sue on this basis, arguing that the law forcing him to be in a separate car, and in this case would have been a lower class car, was actually unconstitutional. This course made its way to the Supreme Court of the United States after it passed through state and local courts at the Louisiana level. Now, the fundamental question that went before the Supreme Court in this instance was actually very much about the 14th Amendment. Is that Separate Car Act, which is to say mandating separate seating for black people and white people in a train, is that actually a violation of the 14th Amendment of equal protection under the laws? Now, at the time, what the Supreme Court said was actually, no, it's not a violation. They said that separate but equal accommodations are legal. Now, you're probably familiar with the basic logic of this decision itself. If you are going to provide a separate car for black people and a separate car for white people, but they are essentially the same when it comes to the quality and provisions that are actually involved, then it's not necessarily treating you any differently under the law than you otherwise would be. However, there's some additional pieces to that the court uses to justify their decision that I think are worth noting. The first has to do with a denial of just how much racism is actually involved, or racism in the sense of creating a second-class citizenship. One quote that you can see from that Supreme Court decision, the plaintiffs, this case meaning Homer Plessy and his lawyers, have the assumption that the enforced separation of the two races stamps the colored race with inferiority, a badge of inferiority. If this be so, it is not by reason of anything found in the act, but solely because the quote-unquote colored race chooses to put that construction on it. Now, in other words, what they've denied here is that this is meant or is in fact being used as a tool of not just segregation, but subjugation. So in other words, it's obviously, to their mind, not intended as a statement about the inferiority of black people, and that the statute, as far as they're concerned, is not written that way and therefore cannot be interpreted that way when it comes to whether or not to keep it upheld. However, one additional feature of this is particularly interesting in their logic. Not necessarily in trains, but in education. And this is where we get the famous court decision of Brown versus Board of Education of Topeka Schools. I think you could argue that there are a few more important Supreme Court cases within the last century than this one. But I think it's also important to recognize some of the details of how it came to be. You may get the impression it's just about the Brown family. It's actually not just about their story. Theirs is the most prominent among the families that sued. They are residents of Topeka, Kansas at the time. Now, if you look at this picture, Linda Brown, who's about 8 years old when this case is originally filed, she's the one on the far left. They live in a portion of Topeka where the nearest school that they could enroll their children at, Sumner Elementary School, is about 6 or 7 blocks away. And so it's relatively easy for the children to walk to that school safely. However, the school board does not want African American children enrolling at that school. What they're going to do instead is insist that Linda Brown and children like her have to go to a school all the way on the other side of town, a mile away, and it's not as nice a school anyway. It's reserved for non-white students, and it can't just be someplace you get by walking. They actually have to be bused as well. You had, therefore, the parents of Linda Brown try to enroll their daughter in the closer school. When they were denied, they sued the school board. And you had several other cases with several other families in a similar position. And these got argued essentially together when this came before the Supreme Court. Now, what you find in this instance is, therefore, we're back to square one upon a few different resources than they would have otherwise used. And the really remarkable thing is that in this case, it includes something which actually many of you probably have some encounter with right now in some of your classes, which is to say psychology. And in this case, it was a test not only of whether or not separate but equal is legal, but actually what separate but equal does. They relied especially on the research of two psychologists, a husband and wife team, Kenneth and Amy Clark, both of them African American themselves, who did a number of studies in segregated schools in the South to see what effect segregation had on the welfare of school children. One of these tests, as you can see displayed in the lower right-hand corner of your slide here, was the infamous so-called Dahl test. Now, the Dahl test, at least in theory, is not that hard to figure. It's not that hard to figure out. You have a child, African American in this case, with a row of dolls placed in front of them. Some are white, some are not. You have the person who is questioning ask the student various questions about the qualities of the different dolls. Which one is good? Which one is, say, pretty? Which one perhaps is actually the doll that they would like to play with? Now, what they kept finding again and again is that when it came to dolls that they did not want to play with, relative to the white dolls, or that they ascribed bad qualities to, were the ones that they identified as looking like themselves, which is to say, the dolls that were of the skin tone of African Americans. What you had in the case of the Clark's interpretation of this data was something horrifying, and the Supreme Court, citing their research, agreed with them. Namely, what it is that, therefore, segregation does to young people who have to live and work in a segregated school. This is their language from the majority opinion. To separate them from others of similar age and qualifications solely because of their race generates a feeling of inferiority. Note the echo back to the language of Plessy versus Ferguson, as to their status in the community that may affect their hearts and minds in a way unlikely to ever be undone. In other words, what are they saying about separate but equal here? That it damages the development of young people. It stunts how it is that they relate to each other socially, and it leaves scars mentally that are going to be there for the rest of their lives. In other words, the harm is very much internal and it's very individual, in addition to just being a legal category. It's on this basis, among other reasons, why the Supreme Court strikes down separate but equal. And I think that's important to realize because to this point, you had not necessarily seen a lot of court cases decided based on social scientific data like this. You also had not necessarily seen these necessarily argued in the case of discrimination what these laws actually did, not necessarily just the legal logic underlying them.